I was appearing for petitioner Lordship. Lordship, yesterday I returned back the file to the council because he is not listening to the order position.
To your advice.
And I am withdrawing from the case. Lordship. I have already returned the brief to brother of the petitioner.
You have formally communicated.
Lordship, no, Lordship, he has taken back the previous time.
Do one thing, Mr. Kaya. Put a formal
I'll
communication. You place it before this court
no, I've
on the
already-
next date.
Yes, sir.
And we shall struck off your name on the next date. In item 4, heard Mr. S.C. Kayal, Learned Counsel, appearing for the petitioner. Anyone there from the other
Yes.
side? Also heard Mr.
A. Bulwa.
A. Barwal, Learned Counsel for the
Yes.
for the respondent. Stop. Mr. Kayal submits that due to certain development in the matter, he had to return the brief to the petitioner.
Lordship.
However, no formal communication to the same is available on record. Let a copy of the letter intimating return of the brief to the petitioner be placed on record on the next date of hearing.
Lordship.
Relist on such and such date. Yes.
After 2 weeks, Lordship.
Hmm?
After 2 weeks.
On 10th November.
Lordship. Much.
Right.
Please, your Lordship. Lordship, with the
Mr.
con-
Kayal, in your letter, you do indicate for alternative to arrange for alternative
Yes.
representation.
No.
That format you
I know.
generally communicate.
An application also because there is a provision in the.
You need not move an application. You place it on the next date on
Yes.
the basis
Not filed with that.
that indication. And if you want to bring it by with an additional affidavit, that's all right.
Not,
It should be on record.
Lordship.
May it please, your Lordship. Lordship, with the consent of the other side, I beg to mention item number 9 and 10.
Yes.
Lordship, we have to file an affidavit in the item number 10 in the contempt case.
This contempt is connected with the first appeal.
Yes.
Okay. So in the contempt, you are for the respondent.
No, Lordship, for the petitioner.
What affidavit do you want to file in the contempt?
Lordship, an affidavit in reply.
So the contemptor has already put their show cause. According to them, there is compliance of the court's order.
Yes. We have not violated anything on orders of this.
All right, you want to bring something, you bring it. But ultimately, you see, contempt petitions are between the contemptor and the court. You have already brought the non-compliance to the notice of the court. So anyway, you wish to file a reply, you do whatever you want to do. By how much time do you need?
Lordship, 3 weeks.
And item number 10 likhiba first, huh? As prayed for by MS
P. Agarwala.
P. Agarwala, Learned Counsel, appearing for the petitioner, relist after 2 weeks on a date to be fixed by the registry to enable the petitioner file a reply affidavit to the show cause reply submitted by the contemptor number 1 and 2 on a date to be fixed.
Lordship, there's an interim order in item number 9, if that may be
And
explained.
in item number 9, in view, list after hey, to look at Lydia, interim, if any, to continue till the next date.
Obliged.
Or English item number 1.
May I please, Your Lordship. With due respect, Lordship, I beg to, this matter may be adjourned for the day, Lordship.
First item, you want an adjournment. Why are you seeking the transfer? Transfer of what?
Transfer of civil procedure, Lordship.
Huh?
Transfer on title suit from Tinsukia to Lakhimpur, Lordship.
From Tinsukia
To Lakhimpur, Lordship.
to Lakhimpur. Why?
Kindly take the matter after.
Why? Why do you want the transfer? You have a brief, Mr. Counsel. Please open your brief.
Lordship.
Yes.
Lordship, the petitioners are the old age, Lordship. They are suffering from various illness, Lordship.
So because of the inconvenience,
Lordship.
you are Mr. Barua.
Borgunhai, Lordship. B. Borgunhai, Lordship. Next has the.
Now, what is the state of the suit? What is the stage of the suit? At what
Lordship.
state is the suit pending?
The evidence is. there,
Why are you looking to the counsel for the respondent?
Lordship.
You must be aware. You
Lordship.
see, the adjournment is one thing, but you also cannot take the court proceedings for granted. This is the first item on board.
Lordship.
Merely because you want an adjournment, the adjournment may not be given to you. Yes or no? So at least you must be knowing the brief facts of the
Matter.
case. You are holding a brief.
Lordship.
You must open your brief before you make submissions before the constitutional court.
Fix the matter after some time.
No, that, huh?
After some time, Lordship.
After some time, yes, okay. You have a look.
Lordship. Must.
Order item number 2.
Condonation.
Lordship, but there are certain developments in this case, Lordship. Some similarly situated person had filed an LA appeal before this court. That was allowed and amount was enhanced. Thereafter, IOCL had filed a review. Because we are not made a party. That was dismissed because of delay. That went to SLP, Lordship. At SLP, I think that has also been dismissed. Then therefore, I will have to seek instruction in this case, Lordship.
But ultimately, it looks like this may also be dismissed.
Yes, Lordship. Because Lordship, they have the knowledge in 2008 itself. Admission is there.
You want the dismissal today or on Friday? No, sorry, the Monday.
Lordship may give some more time because.
No, what some more time?
They may not pursue this.
I'm
case.
giving you time till Monday. You get whatever instructions you want to get. You have the orders of the apex court.
No, Lord.
So get hold of all those orders.
I don't have the knowledge about that, Lordship.
You please put on, you bring all those decisions.
That's why,
Uh,
Lordship,
I'll give you time.
The document they have annexed itself speaks that.
That's
they-
all right. Let us see what are these orders, because you see, the issue perhaps has already been settled. Heard Mr.
M. Gogoi.
M. Gogoi, Learned Counsel for the applicant, also heard Mr.
And Kolita.
and Kalita, Learned Counsel, appearing for respondent numbers 4, 5, 6, 7, 8, 9, and 10. Government,
For 11, Lordship.
Mr.
T.R. Gogoi.
T.R. Gogoi, Learned Government Counsel
Government.
for Learned State Council. For the state respondent, huh? Mr. Mr. Gogoi submits that a similar issue has been taken before the apex court, wherein, as per the instruction received, the matter has been dismissed. The matter has been the matter has been dismissed. However, he does not have today the orders of the apex court or order of the apex court. Relist after 2 weeks on a date to be fixed by the registry. Let the relevant orders passed in the connected LA. You said LA? Connected?
We had filed a review here against the appeal because we are not made party.
Connected in the other matters.
The date may be fixed, Lordship. I'm not a regular practitioner.
All right. We'll give you a date.
What's-
14 number.
Is 14 November okay?
Yes. Lordship.
Item number 3.
Same law. Yeah, okay. Same Lordship.
Item number 3, same.
Yes, Lordship.
All right.
Much.
For hearing. Supplemental pages, order for the item number 13.
Where is Mr. Soronia? Where is Mr. Soronia? Mr. Chaudhary, can you ask one of your juniors to send for him? Because last time also he was not there when the matter was called. Then he came with his junior to the chamber without. I mean, I would have appreciated if he would have come along with you all. I would have taken it up in the second half. But after fixing a date, it's difficult.
I'll send for him and I'll also call him. I don't know.
Yes, please ask him, because I want to finish this right
Yes.
now.
It has been pending for a long.
Correct. So I want to finish it. Please ask your junior, Mr. Chaudhary.
Item number 5.
Please, your lordship, this matter I need accommodation only for the day, my lord. I misplaced my part of my file, my lord, due to shifting, my lord. Let it be on next week, any day, my lord.
2016 matter.
Yes, my lord. Only for the day, my lord, I am seeking accommodation, my lord.
Your name?
Please, Sundi, my lord.
Mr. P. I've heard Mr. P. Sugni, learned counsel appearing for the petitioner. Also heard Mr.
My name is D. Chakraborty.
A. Chakraborty. B. I was trying to see the initial. B. Chakraborty, learned counsel appearing for the respondent number?
All the-
For the
All the
respondents.
rest.
Mr. Sundi, learned counsel for the petitioner with profused apologies, request posting this matter on any other date as the matter pertaining, as the matter being an old matter, inadvertently the brief has been misplaced. Correct, that's what you said?
Correct.
Stop. Prayer is allowed, relist on such and such date. Yes, next week, give a date.
Seven.
7 November.
My lord.
The Chakraborty, 7 November?
6 will be the hearing day, lordship.
6, okay.
Much obliged.
Item number 6.
Nine the GP subpoint. Item 6.
Yes, lordship.
Workman compensation.
No, lordship, this is an appeal against the judgment and order dated 8/9/22 of the employees compensation, Lakhimpur, lordship. Now, lordship, now herein, the so-called accident, lordship, it had happened on,
This appeal is under section 23.
yes, lord,
23, right?
yes, lord.
Yes.
Under section 30 of the
30.
Employees Compensation Act. lord.
Under section 30.
30.
Act 20. Employers compensation. Yes.
No, lordship. No, lordship, the first and foremost argument on my part is that, lordship, the manner in which this entire matter has been decided, lordship, it's a complete negation of the rights of the parties, audio alternate partum, and the procedures as laid down in the Employees Compensation Act, lordship. Now, lordship, this accident had happened on 6/8/2018. And this
When
petition,
did the accident happen?
6/8/2018, lordship.
6/8,
2018, lordship.
2018.
At lordship, at village Kulbung, Tamenglong district of Manipur, lordship.
Manipur.
Manipur, lordship. Now,
Yes.
yes, and now, lordship, this petition was filed on 2021. On 12/8/2021.
Petition was filed when?
12/8/2021, lordship.
12/1.
12/8,
Sorry, 12/8/21.
2021. Yes.
Yes.
Now, lordship, as per section 10 of the Employees Compensation Act, the limitation is 2 years.
Yes.
The limitation is 2 years. Now,
Yeah.
lordship, herein, some delay has to be condoned and some reasonable explanation has to be provided.
Yes.
No such explanation has been provided.
The delay
Then-
condoned.
Nothing has been seen in the order, lordship.
No,
Please.
there is no delay condonation.
No, lordship. No delay condonation application. No delay condonation. Neither has it been reflected in the order, lordship. In the order of the Employees Compensation or Commissioner, lordship.
This
Now-
point was urged.
Yes, lordship. Yes, lordship. That was pleaded in our earlier.
Then?
Then, lordship, the accident had happened in Manipur, lordship. So actually, the main jurisdiction of the incident was for the Employees Compensation Commissioner in Manipur at that time. And for that purpose, lordship, a notice under section 21 has to be given. It's a statutory notice, lordship, section 21.
Yes. Yes.
Yes, lordship. However, lordship, no such notice has been given. Then, lordship, here, if you come to the procedure, lordship, I am just pointing out to the Employees Compensation rules, lordship. Now, in this case, lordship, no. Now, lordship, in this case, lordship, no witnesses were allowed to be adduced. No witnesses were examined. Even the lordship, the appellant was not even heard. They had contended the fact that the person who died in the incident was not their employee. They were not even allowed to present their argument or adduce any witness, lordship. Neither, lordship, any issues were recorded. Lordship, if we go to the Employees Compensation Rule, lordship.
We will go to the rules one by one.
Yes, lordship.
Anything more? I was just summing up your argument.
Yes,
You
Lordship.
said limitation. issues not framed,
Yes, Lord.
jurisdiction.
Just a statutory notice not issued.
So basically 3 points, you are
Yes, Lordship,
uh,
now,
the major points, right?
yes, Priya.
Issues not framed.
Issues not,
And also you said evidence not taken.
evidence not taken and statutory notice was not issued, Lord.
Jurisdiction also, isn't it?
Jurisdiction also. This is a quite severe matter, different state, Lordship, even not the same state, Lord.
Yes. Now let's go to the facts first.
Lordship. Now, Lordship, now, the facts of the matter is that the accident happened on 6/8/2018. An employee died and the petitioner claimed that the employee was.
Where is the substantial question of law? Is it been framed?
Lordship, it's a MFA petition, Lordship. MFA petition.
Section 30. Is this section 30 appeal?
Yes, Lordship, section 30.
Provided that no appeal shall lie against any order unless a substantial question of law is involved in the appeal. And in the case of an order other than an order such as is referred to clause B, unless the amount in dispute in the appeal is not less than. Are you covered under B?
Lordship.
It's section 30 or not?
Yes, Lordship, 30. Section 30, Lord.
Yes. Section 30, then a substantial question of law has to be framed. Not framed. Today, this has come for hearing. I think it has to be framed.
Lordship, we've already laid out our contentions in the grounds of appeal, Lordship.
That's all right, but
Lord.
there is a procedure. You have to give us the substantial question of law.
First of all, this appeal is not maintainable.
That's another thing, but this court can only entertain the appeal if there is a substantial question of law. You have a look at it, Mr. Counsel. Please examine section 30.
Yes, Lordship, Lordship.
I'm posting it on another day.
Yes, Lordship, Lord.
Do whatever is required to be done.
Yes, Lord.
Do you have a copy of section 13? Do you have the copy of the Employees Compensation Act or not? Open up section 30. Please read it out.
An order whether by redemption.
Read it loud.
Yes, Lordship. Provided no appeal shall lie against any order unless a substantial question of law is involved in appeal, and in case of an order other than an order such as in referred to clause B, unless the amount in dispute in appeal is not less than 10,000 rupees or higher, as central government may by notification of in the official gazette specify. Provided no further that no appeal shall lie in any case in which the parties have agreed to abide by the decision of the commissioner, or in which the order of the commissioner gives effect to an agreement come to by parties.
And there is a decision which says the appellate court has no jurisdiction to entertain an appeal unless the same involves a substantial question of law. So you have to first please do some homework, Mr. Counsel.
Yes, Lordship.
Your name.
K. Das, Lordship.
Heard Mr. K. Das, learned counsel appearing for the petitioner, appellant. Stop. Also heard Mr. B.R. Das, learned counsel appearing for the respondent. It appears the instant appeal is presented under section 30 of the Employees Compensation Act 1920-23. However, no substantial question of law has been formulated in the memorandum of appeal, and neither any such question has been framed by this court before putting the appeal for hearing. Section 30 of so and so reads as under, quote unquote. Mr. So and so, learned counsel for the appellant, seeks 2 weeks time
2 weeks time, Lordship.
to look into the matter and do the needful. List after so and so on a date to be fixed by the registry.
Find out, I think some cases fixed on 6th November, and I am coming.
You're coming from outside? All right.
6th November may be fixed.
That's all right. You see, for date, it is okay. You just have to tell
Yes.
after the order is
No, so
passed.
6 November is all right.
Okay.
Item number 30.
Yes, Mr. Soronia.
My lord, may please lordship, my lord, earlier, my lord. Several times it has been hard, my lord, because of some-
Yes, I remember the matter is, I can close it unless you want to say something.
My lord, during the, my lord, the response number 5.2 affidavit, my lord, which are the court permission, even also, I also supposed to, my lord, counter this affidavit, my
No,
lord.
no, now I'm closing the matter today.
My lord, but others only.
Which are those two
My
affidavits?
lord. Two affidavit, my lord, is filed on. That is not here, my lord, and then, my lord, in the month of October, one is October. One is prior to possibly puja vacation.
Which are those two affidavits?
11 June, my lord. One is 11 June, one is in October, no date is here,
11 June when?
2025, my lord.
It's not here. And who has filed it?
Response number 5, my lord.
Who is respondent number 5?
Response 5, my lord, Jiran Rongping, my lord.
Where is that affidavit? No, not that much.
That's not 11 also, my lord.
We have filed it.
Where is it?
Should be on the record.
Please have a look. I don't think I have seen that affidavit. And it's not even written in the index. Because if I broadly remember, Mr. Soronia, there was 2 points that you had primarily argued.
My lord.
Number one, that though it was the advertisement was for one post, however, 2 incumbents have been appointed. That was
My-
one.
my-
Therefore, you say the appointment is
Right.
illegal because one post was not
My
advertised.
lord.
Correct?
My lord.
And the second argument of yours was that that certificate of equivalence that cannot be a valid degree.
But because of that, but
Yes.
the advertisement is only B.
Correct.
Not
B, not
equivalent.
equivalent.
Not equivalent to any other.
So all right. So these
My-
are the 2
my
arguments.
lord.
Yes. Where is that additional affidavit? It's not here also.
My lord, no,
I am not going into that additional affidavit. It's not in my record.
even without the court permission also.
Yes, we noticed to the court.
That's okay.
Respondent no filed.
But otherwise, you ask a junior to call, ask them to call for it because it's not in the record. So when Mr. Soronia said something has been filed, I was taken by a surprise because I don't remember seeing anything.
Only for the purpose of bringing to the notice the court that he has been promoted.
Okay, that's all right. It will be noted.
Yes.
You don't have to give a reply to that, Mr. Soronia. But give the details. If you filed it, let it be on record. Otherwise, it will be misplaced. And I was just trying to remember, was any argument made by someone regarding the caste thing? That was not
No,
done, no?
My lord.
Otherwise,
And third is, my lord, that the respondent number 4, my lord. Though he is, my lord, suppose, my lord, is otherwise he is eligible, my lord. Suppose, though there is no equivalent to B. Even then, his qualification is not eligible because he has taken for distant education. In case of technical education, distant education is not allowed. Secondly, he is passed out from the Guwahati examination center was in Guwahati. The franchise is not allowed in favor of distant education, my lord, except within the, if it is a state university, within the state, my lord, if it is a central, my lord.
these are all whatever is there in your argument. You have
My-
given your argument.
I have given mine.
I don't want a rehearing. I had kept it
Only
for
the-
clarification today.
Only, my lord, last time I have been asked to, my lord, regarding the maintainability, my lord, that I have.
That you have anything?
That, my lord.
That you can give.
The 4th judgment, my lord, with the synopsis I have.
I think only that point for
My
clarification.
lord. And during the course of hearing, so lordship,
This is, you have already given this, no? Or is this something you have again edited?
my lord, that is only, there are the 12 judgment, my lord, here is 4 judgment, my lord, I have cited.
I thought I have seen something. I was
Maybe, my lord,
the duplication of the same thing will make it more complicated for me. I want to finish this. You know, it is not going to do any good to anyone by keeping this matter. So this was for you, short argument on petitioner. Now you are giving any another notes, but this is specifically on maintainability. Okay. Very well, closed. Closed for judgment.
Highly obliged. Lord.
Number 7.
May it please your lordship. Lordship, my senior is in lex in another court, lordship. May be taken at 2.
My lord, in this matter, my lord, in every occasion, my lord, this happens. my lord.
Huh?
In every occasion, for the last 4 occasions, my lord, when the
No,
matter,
you ask him, I'm passing it over for some time. Otherwise, Mr. Counsel, please look into the brief. If your senior is occupied, you will have to present the case. So look into the brief till then.
May it please your lordship. Lordship, we are challenging the interim judgment and order dated lordship 12/4/2023. Passed in original application number 25 of 2016. Lordship will find it.
This is section 30.
No, Lordship, it is filed under section 23 of the Railway Claims Tribunal Act 1987.
Section 23.
Yes,
Section
Lord.
23. By the railway tribunal.
Railway Claims Tribunal.
Yes.
So we are aggrieved with the judgment and order dated 12/4/2023.
Judgment date is
12/4/2023.
12/4.
Yes, Lordship.
24.
23.
23. Yes.
Passed in original application.
Which
Yeah.
page will I find this?
Lordship, page 15.
Page 15. Yes.
In this case, Lordship, the appellant is a sender, is a consigner as well as the consignee who booked a demand of 42 BCN rake, Lordship.
42?
BCN rake,
Yes.
class of rake, Lordship. So he has just placed a demand, Lordship, on 25/8/2015. And the Lordship, it was meant for 2 rake point, Lordship, 2 destination point.
Yes.
One is for Harmati and other one is for Dekagaon. So 42 BCN rakes divided into 2 parts, like that is 21 BCN, 21 BCN each, Lordship. And accordingly, Lordship, he made this demand in terms of the Railway Board Circular dated 5/6/2015, where it has been mentioned that under clause 5.0, 42 BCNs were required for 2-point rake combination, and we will get the benefit of train load class. That is 100, Lordship, train load class it. On the basis of that class, Lordship, freight will be calculated. So we are guided by this Railway Board Circular, Lordship. And accordingly, we have paid rupees 52,100 as wagon registration fee, Lordship.
Which is this railway good circular?
It is in the
available?
LCR, Lordship.
The case records have come.
Yes, Lordship.
Yes.
So in terms of the circular dated 5/6/2015, we made a demand for 42 BCNs of rake, Lordship. Accordingly, rake was supplied, Lordship, and the forwarding note is executed, Lordship. Forwarding note will be executed under section 64 of the Railways Act 1989. So it will be, it is the primary document, Lordship, which will filled by the sender, Lordship.
Yes.
Lordship, the circular is at page 33,
Page 33 of this.
LCR.
Ma'am, try and use the word trial court records or the tribunal records.
I apologize.
30.
33.
You
Lord.
don't have to apologize. It's just we are trying to make corrections here because it's not appropriate to refer the tribunals or the trial courts as lower court. They're not lower to the high court. 30,
33.
33.
Yes.
Pagination tool of various enemy. 53. Can you do one thing before we start with the proceedings? Can you just quickly flag up whatever you want to
Yes, sir.
rely from the case records? Take your time. In the meantime, I'm just seeing the judgment. You are the sender, so your claim has been rejected.
I don't know.
Yes.
Lordship, I have flag mark, Lordship. The circular dated 5/6/2015, pink flag. Lordship.
28/5/16.
No, Lordship, 5/6/2015.
Yes, I got it.
So this is the circular under which we have booked the 42 wagons, Lordship.
Hmm.
In this circular, it is clearly mentioned, Lordship, guidelines for transportation products like block rates, mini rates, 2-point rate, multi-point rate, 2 and multi-point rate, rakes from two originating terminals and rakes from two originating terminals have been laid down in para 5.0 of the above referred rates master circular. The same has been reviewed and it has been decided to issue the guidelines contained in para 5.0 of the above referred rates master circular as a separate rates master circular. It also contains the revised list of combination of 2-point destination as annexure 1. This revised list will come into force with effect from 15/6/2015. Then Lordship,
What was that you were transporting?
Lordship, we are transporting salt, Lordship.
Huh?
Salt.
Salt.
Yes.
And you had booked two rakes,
Two rakes
two rakes,
meant for combination of 2-point rake combination, Lordship.
2-point rake combination.
Lordship may find it at paragraph 11, Lordship.
Okay.
20
Okay.
first page.
And it says the same, it has to be done in para 5.0 of the above, so and so.
Yes,
The same has been reviewed.
yes.
So according to this, what has to be done?
So
The methodology of calculation.
calculation of the freight.
So you, for what you are trying to say is that the tribunal has not correctly calculated.
No, Lordship. Here, Lordship, we are basically wanted to book the consignment under the train load class of 100. So from there, Lordship will get the benefit in the freight, Lordship. But here, the railways have
I
collected.
think, ma'am, let me first go to the facts. Take me to the claim tribunal's order,
Yes.
because let us have the fact, then you can argue the law. Because otherwise it is, I'm not being able to appreciate your argument, because briefly I understood what you are trying to say is that they have not correctly applied the applicable
Of the circular.
circular. This is, so
This
in
is the
short.
case. This
So
is-
according to you, this is the material irregularity committed by the claim tribunal, correct?
Yes.
So this is the error, isn't it? All right, let's see the order under appeal.
Yes, Lordship. May I read, Lordship?
One second. Rupak. Huh? Are you carrying any authority on the power and scope of section 23?
Lordship?
Are you carrying any
Yes,
authority?
Lordship. I have the act, Lordship.
No, the
Railway case.
act is okay, but any decision, because what is the question of law involved? Any substantial question of law is required?
No, Lordship. No, no.
Are you sure?
Yes, Lordship. This is a miscellaneous first appeal, Lordship. So here substantial question of law is not required, Lordship.
No, but this is an appeal under section 23.
23, Lordship.
Where is the order?
Order of the Tribunal, Lordship.
Yes.
It is at page 15, 15. In the memorandum of appeal.
Page 15.
Yes, Lordship.
Page 15 is slightly not, the certified copy is also there. Okay, it's the same. Yes, read.
This application is filed under section 23 of the Railway Claims Tribunal Act 1987 by the applicant for an award of rupees 27,54,222 along with interest and cost of litigation on account of alleged freight overcharged by their respondent. Brief history of the case of the applicant is that 21 wagons of iodized salt were booked under invoice number 3 railway receipt number such and such dated 30/9/2015 ex Chirai, Lordship. This is a short form of station Chirai to Harmati, and 21 wagons of iodized salt were booked under invoice number 8 railway receipt number such and such dated 30/9/2015 ex Chirai to Dakargaon in train load condition. The applicant has stated that he is the consignor and it paid all freight money of rupees.
Yes.
The applicant has stated that he is the consignor and it paid all freight money of rupees 55,08,341 at the time of booking at Chirai, while money receipt number so and so dated 30/9/2015. But on the next day, that is on 1/10/2015, the railway at booking point collected additional freight to the tune of rupees 27,54,222.
Your Lordship, may I take 5 minutes leave from Your Lordship, 5 minutes break?
So you want to take that risk, go ahead. But
Your
you-
Lordship, one important matter is in.
No, I am okay for you to take as many
I-
breaks, Ms. Fukan, you want to do. But you are going to give reply to the arguments being
Yes.
made. This matter is being taken up for hearing.
Yes.
So
Just
it
2
is up
minutes,
to
just
you,
2 minutes.
Ms. Counsel, it is up to you how you want to give your reply.
Yes,
Because generally you have to reply to the arguments made.
Yes, Your
So,
Lordship.
no, that is all right, but you should have had some alternative arrangements. You are the state council here.
Yes, central government.
So central government, then you must, you should have ensured some other central government advocate as well to
I've
be
been
here.
doing
This is
matter.
not the way the government councils operate. Matters are taken up for hearing. You cannot go for a short break when the matters are going on unless
Not
you.
break only for 2
You see, Miss Counsel, you can have someone sitting here to take notes for you while you
Okay,
go and
okay,
attend your other matter and come. These are known procedures.
Yes, Your Lordship.
But you can't have it totally unattended. You have to give your response. You
Yes.
could have asked one of your colleague to just cover up for you while you go and attend to the other court. These are procedures which we are all familiar with. Nothing unknown. Please do whatever you want to do. Yes.
Okay, then I'm not going.
No,
Sorry.
if she is there
Yeah, I
to
got it.
take note, then it's all right. Let her sit and you do and come. But you see, if yes,
Sorry for that, Your Lordship. I'm coming.
yes,
But on the next day, that is on 1/10/2015,
an idea.
the railway at booking point collected additional freight to the tune of rupees 27
Miss
lakhs
Counsel, take your seat. Take your seat.
to the tune of rupees 27,54,222, white money receipt number 542025, treating the booking of consignment under wagon load condition. Despite the fact that the consignments were booked under train load condition. The applicant stated on the strength of Railway Board Circular number so and so dated 5/6/2015, which permitted booking of 2-point destination rate, that is for destination Harmati and Dekagaon under train load benefit. It submitted demand intent on 25/8/2015 for supply of 42 wagons for 2-point destination rate, namely Harmati and Dekagaon under train load benefit, and paid rake load wagon registration fees of rupees 52,100. The applicant also stated that on the basis of their forwarding note, the railway at booking point correctly calculated and charged freight of rupees 55 lakhs 8,341 on train load rate for 2 rake point under class 100. The applicant further stated that it is a fact that 2-point rake consisting of 42 BCN wagons were placed for loading at Chirai at about 11:55 hours on 30/9/2015, and the loading of said 2-point rake was completed at 1900 hours on 30/9/2015, and the rake was moved for 2-point destination on 1010 hours on 1/10/2015. That on the next date, that is on 1/10/2015, when the applicant approached the booking station to collect the railway receipts, the Chirai goods could not download the correct railway receipt, as the computer system was showing freight charging class to be 150, which is applicable for wagon load, instead of class 100, which is applicable for train load. The CGS Chirai goods issued XSR dated 1/10/2015 to OCC NDLS Senior DCM ADI and OCWRHQ, stating, please rectify the above matter, Harmati 21 BCN, Dekagaon 21 BCN. This is approved combination on NF Railway serial number 13, but the system is charging wagon load class 150. Please grant train load class 100 in RI source. Thanks. And that the CGS goods inform that as per revised Railway Board circular number so and so dated 18/9/2015, which is effective from 28/9/2015, 2-point rake load is permitted only in BCN HL wagons. Hence, railway receipt under train load condition could not be downloaded. The applicant further stated that the entire facts were brought to the attention of CCO cum CCM FM Western Railway, who after getting the matter inquired, issue a letter bearing number so and so dated 20/27/11/2015 to the Executive Director Traffic Commercial Rates Railway Board, in which it admitted the mistake and failures done by the railways. Para 3. The respondents filed their written statement resisting the claim of the applicant. The respondents averred that as the applicant has not filed the company board resolution or authority letter or power of attorney along with the claim application to prove his authority, the claim application is bad in law and not maintainable. The respondents also averred that Railway Board wide notification number so and so dated 18/9/2015, corrigendum number 2, revise the policy guidelines on 2-point combination, as per which the train load benefit shall be extended to the party for 2-point combination only if it is loaded in BCN HL wagon and not in BCN wagons. The respondent admitted that the booking station calculate the freight at train load rate, that is class 100 on forwarding note, and collected freight amount of rupees 55 lakhs 8,341, but averred that as the system did not permit or accept train load class, undercharge of rupees 27,000 lakhs 54,222 was recovered at wagon load class from the consignor. The respondent averred that freight was correctly charged as per the revised Railway Board's notification number dated 18/9/2015. The respondent denied that there was gross negligence and misconduct on the part of the respondent railway, that they are guilty of breach of contract, malfeasance, misfeasance, and that they are liable to compensate for the loss suffered to the applicant with full cost and interest. With these averments, the respondent prays for dismissal of the claim application with cost. Para 4. The following issues were framed on 19/10/2016 after receipt of written statement from Western Railway. Number 1, whether the respondent is liable to charge on wagon load charges or train load charges at the time of booking of the consignment. Number 2, whether the applicant is entitled for refund of excess charges to the tune of rupees 27,54,222 with interest from the date of booking or payment till recovery from opposite party. Number 3, relief. Para 4.1. However, after receipt of written statement from NF Railway on 13/4/2021, with the consent of the
One
parties.
second.
Yes, sir.
Yes.
However, after receipt of written statement from NF Railway on 13/4/2021, with the consent of the parties, the following issues were framed. It is again repeated, Lordship. Para 5. In this case, neither party adduced oral evidence in support of its claim. The applicant has filed original copy of claim letter dated
No,
7.
but the issues are these three issues ultimately
Yes,
framed.
Lordship.
So ultimately, the issues framed are these four issues.
Yes.
Whether statutory legal notice under section 106 has been duly served, whether
Whether
the
the
applicants
applicants-
hold legal title, whether the applicant is entitled for compensation as claimed in the claim application, and to what extent. Now, 106 is a statutory notice which has to be given by whom?
By the standard.
So by you to the railway. So there has been a dispute to that. So that is why that is an issue.
Did our claim, Lordship?
No, basically, whether it has been duly served or not.
It is served.
No, no.
Lordship, in the.
You see, I'm only trying to understand the issue. Factually, I'm not there. And this is now the appellate court. So this is not the court which will go enter into the facts area, correct? This court will only determine whether any question of law arises or not. If the question of law arises, whether the same is either any jurisdictional error has been committed. That is the limited jurisdiction of the appellate court under section 23 of the act, right? So facts I'm not going, but only I'm trying to understand
Understand
it
the case.
so as to I can appreciate the argument that is going to come from you. But now the issue, going by the issues frame, looks like they have disputed the service of the statutory notice.
Yes,
That
Lordship.
is why that is an issue.
That is
So
the
that service itself is under dispute. So suppose the court has said that the service has not been served, then everything goes perhaps there only. And also your legal title,
Legal title.
that is also a dispute.
Yes.
Yes, let's carry on.
Para 5. In this case, neither party adduced oral evidence.
What is your name?
Manisha Sharma.
Sharma. Yes, Ms. Sharma,
Yes.
carry on.
In this case, neither party adduced oral evidence in support of its claim. The applicant has filed original copy of claim letter dated 7/10/2015, copy of charges for registration of wagons issued by CGS Western Railway, Chirai, Railway Board's rate circular number 14 of 2015, dated 16/5/2014, forwarding notes, money receipt number so and so issued by Western Railway, type copy of message issued by so and so on 1/10/2015. Railway receipts, copy of Railway Board's letter number dated 5/6/2015, Railway Board's letter number so-and-so, corrigendum number 2 to Rate Master Circular, Block Rakes, Mini Rake for 2-point combination, etc. 2015, dated 18/9/2015, CCO Western Railways letter dated 21/3/2016, amended claim letter dated 13/6/2016, along with 2 original postal receipts, PIO and DCM Western Railway.
All right, come to
Neither.
para 7.
Yes, Lordship. Issue number 1 and 2 are decided together, Lordship.
Yes.
Para 7. The consignment was booked on 30/9/2015. Claim letter dated 7/10/2015 was served by Shriram Kemfood Private Limited, receipt of which was acknowledged by the Office of the Chief Claims Manager, Western Railway on 7/10/2015. As per copy of railway receipts, the applicant herein is a consignor. Perusal of money receipt bearing number so and so issued by Western Railway shows that freight of rupees 55,08,341 and 27,54,222 were collected from Shriram Kemfood Private Limited. Thereafter, counsel for the applicant served amended claim letter dated 13/6/2016 to the respondent number 1 by post and to the respondent number 2 by hand, which was received by the office of the respondent number 2 on 14/6/2016. The claim application filed in this tribunal is verified, stamped and signed by Shri Alok Jain, Director for Shriram Kemfood Private Limited under verification. in his affidavit dated.
All right, so this has been decided in your favor.
Yes, Lordship.
Very well.
Both the issues
So
are,
no need then.
yes, Lordship.
Yes,
The main issue is issue number 3, Lordship.
yes, para 10.
Para 10. The claimant has argued that he is the consigner and that he has paid all freight money of rupees so and so at the originating station, that is Chirai. He has also stated that he had placed the Indian bearing number C312547 dated 25/8/2015 for supply of 42 wagons for 2-point destination with Harmati and Dekagaon under train load benefit and paid rake load wagon registration fees of rupees 52,100. Perusal of the documents attached along with the application reveals that the indent was placed for 42 BCN wagons. The forwarding note submitted by the claimant also mentions BCN wagons. The claimant has alleged that though the indent was placed for 2-point rakes and the forwarding note was also given for 2-point rakes, and initially railway charged freight at class 100, the rate for the train load, and the said charge was deposited by money receipt number 542024 dated 30/9/2015, but later the railway demanded another rupees 27,54,222, stating that rake load is permissible only on BCNHL wagon and not on BCN wagon. The claimant has attached Railway Board's Rates Master Circular number so and so dated 5/6/2015, which mentions the policy guidelines for block rakes, mini rakes, 2-point rake, etc., wherein Harmati and Dekagaon are mentioned as permitted combination for station for 2-point rakes. However, the railway administration later realized that 2-point rakes load facility was not available for BCN wagons, but was available only for BCNHL wagons as per the Railway Board's Race Master Circular number so and so dated 18/9/2015 and Railway Board's corrigendum number 2 to Rate Master Circular number dated 5/6/2015, wherein it is stated that 2-point rake can be loaded at train load class rate only for BCNHL wagons. Since the consignment was loaded in Lordship, it should be BCN wagons as demanded by the consigner, hence rate for wagon load was applied.
So actually, initially the railway, because you have applied for train load, right?
Yes,
Your application was for train load. Now they applied what?
they applied later. They realized that it should be calculated under wagon load,
Not under train load.
not under train load. But previously they have accepted our conditions and they have accepted the freight rate calculated under train load class. And
And
accordingly,
then, but later they realized that this should not have been done under train load, but under
wagon load.
wagon load.
Because we have opted for this BCN wagons. And they are saying that train load condition will be applied only in BCNHL wagons.
Train, 1 second, BCNHL. And train load is on?
Train load is on, Lordship, will be applied only in BCNHL wagons, not in BCN wagons. It is their contention.
No, but you have you have applied
For
BCNHL.
BCN wagons.
BCN.
BCN wagons.
BCN. This is what you have opted.
Yes. As per the circular dated 5/6/2015.
Now, according to them, in BCN,
HL. BCNHL.
BSN, I'm getting confused with this. You opted for what? BCN?
BCN, Lord.
BCN.
Yes.
Now for BCN, as per the circulars, it is train load or wagon load?
Train load, Lordship.
Train load. Now then, why are they saying that it should be BCNHL?
Later, Lordship, one circular was issued, Lordship, that is 18/6/2015, which is a corrigendum number 2
Yes.
to the previous circular dated 5/6/2015.
Yes.
Where it is mentioned that train load benefit will be granted only in BCNHL wagons, not in BCN wagons.
So therefore, they are saying that it should not have been
Yes,
train load, but wagon.
wagon load.
Okay.
Now, difference will come in the freight, Lordship, calculation.
Okay.
Yes, sir.
But that 18/9/2015 is applicable to you?
No,
Because
Lord.
no, in the sense because you made the application when? When did you make your 25/8/15?
Yes, Lordship.
That
And
was before the
before the circular.
before the circular. So this is what you're going to argue. Acha. Okay.
Because based on that circular, Lordship, we have paid our fees, Lordship, wagon registration
So
fee,
earlier that was not required.
not required,
Earlier for BCN it was train load.
train load.
Only after 18/9/2015 it says that for BCN HL
Train load grant benefit will be granted.
train load will be benefited and wagon load will go on will be given to the BCN,
Yes, Lordship,
which is higher.
which is higher.
So therefore you are undervalued.
Yes.
Okay.
So they have collected under charges rupees 27 lakhs 54,000.
Got it. Yes. Carry on.
Yes. Since the consignment was loaded in BCN wagons as demanded by the consignor, hence rate for wagon load was applied and accordingly undercharge of rupees 27 lakhs 54,222 was demanded and realized from the consignor. The argument of the claimant is that he had intended to carry the consignment at train load rate, as is evident from his indent and forwarding note. The zonal railway was also initially unaware of the corrigendum number, a corrigendum issued by the railway board and charged on train load rate. The claimant has argued that the respondent Western Railway has admitted the error on their part and has quoted the content of letter number so and so dated 20/27/11/2015 issued by Shri H.L. Meena, CCO cum CCM FM Western Railway to the Executive Director, Traffic Commercial Rates Railway Board, which is reproduced below. The corrigendum of 18/9/2015 issued by Railway Board was received by our office on 21/9/2015 and circulated by ARN number 112 goods of 2015 dated 28/9/2015 to the divisional office. It seems that same information did not reach to the CGS on time before booking the consignment, as the circular was marked to all concerned by board. Hence, operating count have supplied BCNHL rakes only in light of revised policy, as the indent was for 2-point combination. As a corrective measure to overcome the above anomaly being repeated again, it is suggested that the FOS and TMS system be enabled to disseminate message or the whole circular via pop-ups so that both operating and commercial officials are updated with policies with delays. Both kind intervention is therefore invited to treat the above incidents as an exemplary case during the teething period, implementing both guidelines. So based on this letter, it is clear that Lordship, it was not in their knowledge. So lacking is on their part, Lordship.
Not knowledge is one thing, but it looks like you had applied, you placed the indent on 25/8,
2015.
isn't it?
Yes, Lordship.
25/8/15 indent.
And forwarding note is also executed on the same date.
And this money receipt is what date?
Lordship, money receipt.
39.
Yes. Railway received this is.
So the indent was placed on 25/8/15 and then forwarding
Forwarding note was also executed on the same date, Lordship,
25/8/15.
where they have calculated the freight on train load.
This
class.
was where which these are available?
It is there, Lordship.
Calculated. And you paid when?
We paid on 30/9/2015.
39/15
2015.
paid.
Rupees 55 lakhs, Lordship. 55 lakhs,
This
8,000.
point was taken or not taken? Retrospective,
Lordship, we have clearly mentioned in the claim application.
have you taken? I will argued because what court is finding is
Yes.
that if the indent was placed on 25/8/15 and the freight was calculated on 25/8/15, on which date the circular 5/6/2015 was operating the field,
Yes, Lordship.
then
And
nothing is wrong.
nothing is.
Because subsequently only on 18/9/15 there has been some changes.
Yes, Lordship.
And the same was communicated to the railway authority thereafter. But in your case, though you made the payment later, but indent was placed earlier
Earlier.
and they have accordingly calculated.
Yes, Lordship.
and according to the calculation you have paid.
Yes, Lordship. We have made this contention in the claim letter under section 106, Lordship. It is there in the letter.
Yes.
Para 11, Railway Administration is required to charge freight at the rate prescribed by the central government, and we find that in the present case, the freight has been correctly charged in accordance with Railway Board's Rate Master Circular number so-and-so dated 5/6/2015 and corrigendum number 2 to Rate Board's Rate Master Circular number so-and-so dated 18/9/2015. Para 12, Section 78 of the Railways Act 1989 states as under 78. Power to measure, weigh, etc. Notwithstanding anything contained in the railway receipt, the railway administration may, before the delivery of the consignment, have the right to, number 1, remeasure, reweigh or reclassify any consignment. 2, recalculate the freight and other charges. And 3, correct any other error or collect any amount that may have been omitted to be charged. Lordship, under section 78, power has been given to the railway authorities to
Recalculate.
remeasure, re-verify, reclassify the
Freight.
freight, Lordship.
Recalculate the freight, correct any other error, collect any amount or that may have been omitted to be charged. But at the time of charging, 18/9 had not come
Not
into operation. Yes.
Para 13. The corrigendum was issued
The corrigendum was made effective from 28/9/15.
2015. Thus, the averment that neither the consignor nor the staff of Western Railway was aware of the corrigendum has no force. Para 14. In the instant case, the applicant has not disputed issuance of corrigendum dated 18/9/2015 by Railway Board stipulating therein that the train load benefit will be applicable to BCNHL wagons only for 2-point combination destination, and the same being with effect 28/9/2015.
So they have taken it on 39, the day when the payment was made.
Yes. This corrigendum was issued on 18/9/2015.
Correct, which came
With
into effect on
28/9/2015.
28/9/15, and you deposited the money
On
on
39.
39/15, that is 2 days
2 days
after the
after.
corrigendum came into effect.
Yes, sir. The applicant has also not disputed that as on 30/9/2015, the aforesaid corrigendum dated 18/9/2015 was in force. The only contention of the applicant is that the said corrigendum dated 18/9/2015 was not widely circulated, and concerned station booking clerk was not having knowledge of aforesaid position, and therefore the applicant is not liable for wagon load. The applicant heavily placed reliance on letter dated 20/27/11/2015 issued by CCO cum CCM FM Western Railway, Mumbai to Executive Director Traffic Commercial Rates Railway Board, New Delhi, and argued that the respondents have admitted their mistake. We have gone through the said letter dated 20/27/11/2015, wherein it has been stated that the corrigendum dated
This
18.
this will not take you anywhere because that correction power is there.
Yes,
Section 78 is there.
70.
So that I don't find any material irregularity as far that part of the order is concerned, saying that maybe at that time they did not have knowledge. That can be correct. And they're admitting that they made a mistake. All that is okay. But but what cannot be overlooked is that the corrigendum has come into effect on 28th of September. That cannot be overlooked. And your payment was made for the rakes thereafter.
Thereafter.
Now the question is,
Yes.
because you placed the indent earlier, based on that, the calculation was made as per the applicable circular. On that day, this corrigendum did not come.
Yes, Lordship.
So what would that be? Would that make any effect? You may, because it looks like you had ultimately transported the consignment post 30 September, correct?
Yes, Lordship.
That is why you made the payment on 30.
30.
When did the consignment left?
On first 1/10/2015.
Give me these dates now, huh?
Yes, sir.
Indent,
Indent was placed on 25.
1 second. Indent is 25/8/15.
2015. Forwarding
Calculation,
calculation was made in the forwarding notes dated 25/8/2015.
calculation for the note. This is communicated to you.
Yes.
But this is like an, what?
Under RTI, we had came to know about.
No,
this
but
fact.
how did you know how much you have to pay?
Lordship, in the railway receipt, they have mentioned the freight, Lordship.
Which is, when was that given to you?
1/10/2015. Though the amount was collected on 30/9/2015.
No, on that day, how did you know how much you have to pay?
Lordship, because the computer system did not accepted the amount, Lordship, under train load. Because the system shows that this will be applicable only in BCNHL wagon. So you have to pay additional freight of rupees 27 lakhs, so and so that amount, Lordship. We
So-
came to know on that point of
On
time.
30,
On 1/10/2015.
when you were making the payments.
No, when we visited their office to collect the railway receipt. The proof of amount is reflected in the railway receipt. And this railway receipt was executed under section 65 of the Railways Act 1980.
Ms. Counsel, what I'm asking you is that when you place an indent, do they communicate to you that this is what you have to make payment, or you know it,
Lordship, we came to know from them, Lordship.
how much you have to pay?
Yes,
So how do you know about that?
through forwarding note, Lordship.
That was not given to you
It is there, Lordship. They have,
later on.
yes, Lordship.
But on 30, when you made the payment, how do you come to know how much you have to make?
Lordship, the computerized railway receipt was generated, Lordship. From there, we'll keep.
Where is that?
It is there in the trial court, Lordship.
And that was generated on 30.
30,
So that receipt is given to you at the counter.
yes.
And when you see the receipt,
Though the receipt was issued on 30/9/2015, but that was handover to us on 1/10/2015.
I'm not asking you that.
Yes.
See, try and understand what I'm asking. Because this is a little new to me. So what I'm trying to understand is, because if tomorrow I want to send a package, I will go to the railway station. I'm going to make the order, right? So they have to tell me
Yes.
that this is how much you have to pay.
Yes.
Only then I'm going to make the payment. And once I make the payment, they will give me a receipt,
Receipt.
right?
Yes, Lordship.
So that's what I'm trying to ask you. When you placed an indent, they will tell you that this is the amount
Yes.
which you have to pay. Where was that told to you? When was that told to you, and how was that told to you?
They have intimated us on 25/8/2015.
How?
By executing this forwarding note, Lordship.
But that's not given to you.
That was not given to
Then
you,
how
but
do you
later
know?
when we,
So how do you know on 25 or on 30 that this is the amount?
because they have calculated the freight.
That I have understood. But how was this communicated to you? Was it told to you verbally?
Yes, Lordship. In the counter itself, we came to know, Lordship.
Ms. Counsel, Ms. Sharma, please try and understand the question of the court. I'm only trying to ask you that when you place the indent, how did they tell you that you pay so much rupees?
Lordship,
They
what-
must have communicated to you, either verbally, they must have across the counter, or they may have given you something that, yeah, this is your calculation. And accordingly, you must have paid it on 30th.
Yes, Lordship.
And after payment, you need the receipt, which on first you said they didn't give you. Correct. Then you may have made those RTIs.
Correct. They made that calculation in the forwarding note and which was handed it over to us, Lordship. And based on that calculation, we paid the amount on 30/9/2015 in the counter. And later on 1/10/2015, they have issued the generated railway receipt to us. And we came to know that this will be calculated under wagon load because BCN wagons will be not applicable.
Then you paid the remaining,
Additional amount.
you paid the additional amount.
Yes. Because at that point of time, consignment were already moved, Lordship, from the booking station. So we had no option.
Ms. Sharma, I think you don't have any case.
Lordship, my only issue is that if whether the railway can charge higher amount by
You see, Ms. Sharma, this is a limited jurisdiction. Admittedly, on 2023, the circular of 18/9/2023, 2015 had come into force.
true, but Lordship,
Communication, non-communication is something different.
Lordship,
And section 78 empowers the railway authorities to recalculate, remeasure, reweigh, or reclassify any consignment, recalculate the freight and other charges, and correct any other error or collect any amount as it may have been omitted to be charged. So there was an omission on their part because on that day they didn't know. In fact, on 25/8/2015, there was no such circular also. But the day your consignment moved, that circular was in force.
yes.
The day when you made the payment, that circular was in force. So how can you say that the railway authorities has faulted? In fact, if they don't charge, that would be at fault. That would be definitely undercharged.
In this
You
regard,
satisfies me. What is the what is the patent error? I'm sorry, but I don't see any error here.
but Lordship, here I would rely upon two judgments of this honorable court, Lordship.
Yes,
based on
judgments we
which
will go, but
the railway cannot charge
we-
higher amount by
no
paying-
higher amount has been charged, Miss Maya Sharma. No higher amount.
Lordship, by
I am with you till that point. That if there was a higher amount, of course, but that has to be applicable in the context of your case, Ms. Sharma. Suppose this corrigendum 18/9/15 had come into force post 30. Definitely you had a case. Your consignment left on 30, on first they can't say, ki, no, you pay higher charge. That can't be.
but Lordship,
But when on 39/20/2015, this has come into operation. Yes, let's finish it because I think, yes. Page 21, I think you were reading, no?
yes, Lordship,
Yes.
para 14.
Yes, please read from the applicant heavily placed. Yes, that I
The
think
applicant heavily placed reliance on letter dated 2020.
that I think you've already yes, you can turn the page. Corrigendum did
Number
18/9.
18/9/2015 issued by board was received on 21/9/2015 and circulated by ARN number so and so dated 23/9/2015 to the divisional office. In the said letter, it is admitted that the same information did not reach to the CGS on time before booking the consignment, and operating department could have supplied BCNHL rakes only as the indent was for 2-point combination. It is further submitted that therein that as corrective measure and to overcome the above anomaly, POIS and TMS system be enabled to disseminated message for the whole circular via pop-up so that both operating and commercial officials are updated with policies without delay. By this letter, an advice was sought whether the excess amount levied on the freight customer present applicant in light of above circumstances can be refunded. The board, in response to aforesaid letter, while letter dated 3/2/2016, desired strict action to be taken against the erring official. It is also an admitted position that on next date, that is on 1/10/2015, the applicant approached the booking station Chirai goods to collect 2 rake loading point booking RRs. However, the system did not permit to accept the subject loading as train load class 100 and indicated as freight charging class 150 as applicable for wagon load in view of revised policy. From above, it is abundant clear that there was a mistake or error on the part of booking clerk concerned station, thereby not charging applicable wagon load freight charges class 150, and same was revealed when the system indicated freight charging class 150 applicable for wagon load. As already referred herein above, Section 78 of Railways Act 1989 clearly stipulates that Railway Administration may, before delivery of the consign, have the right to remeasure this. This is the thing, Lordship. Now, does the error on the part of CGS or on the part of any railway official in levying the incorrect freight charges cannot be a ground for refund of the freight? That any deviation from the prescribed rate foreseeable at the relevant time would be in fact violative of Section 70 of the Railway Act, which reads as under 70. Prohibition of undue preference. A railway administration shall not make or give any undue or unreasonable preference or advantage to or in favor of any particular person or any particular description of traffic in carriage of the goods. Para 16. The learned counsel for the applicant, while arguing, placed heavily reliance on the judgment and order dated 31/8/2012 passed by Honorable Guwahati High Court in WPC. Lordship, this should be WPC.
So you basically, your claim was for refund.
Yes. WPC number 328/2000.
All right.
Yes.
Yes. What authorities you want to show?
Lordship, I have prepared a written argument, Lordship, for Lordship convenience. Just copy to confirm.
Look. Yes.
I would like to place a reliance on judgment of Honorable Supreme Court in Navjyoti Corporation Group Housing Society versus Union of India, 1992, 4 SCC 477. Lordship will find at page 24, Lordship, of my written argument. This
On
judgment,
what point?
this judgment is basically based on the doctrine of legitimate expectation, Lordship.
But Miss Counsel, please confine your authorities to the patent error. Legitimate expectation is a different concept. It will not come here because you see this court, there can be two views. Now, mainly because the other view, this court is not going to upset. I'm now asking you, what is the patent error? Error could have been if a provision has been ignored, if there has to be something patent, correct? That appears to be not there. All right, legitimate expectation. I'm taking your arguments. Paragraph.
Lordship.
Paragraph. Anila decision scheme. Anna. Jimmer.
As a person can be seen to have legitimate.
Yes, Miss Counsel, paragraphs.
Lordship.
Okay, next decision. Let's go to the next decision.
Next decision is of the Honorable Guwahati High Court, Lordship,
Page.
page 53.
Yes, on what point?
Lordship, this is a similar case, Lordship. Here, the issue before the Honorable Court is that once rate was fixed by the railway administration at the time of booking of the goods, it could not charge higher amount by bringing a different classification when no suppression or misrepresentation was made by the customer.
But here 73 was not argued.
No.
Yes, okay.
So here the Honorable Court held that lordship in
Okay.
page 54.
Yes, I've seen.
Yes, lordship.
All right. That's all?
Another judgment is also relied upon lordship MFA 50 of 2013, page
Yes.
55.
Yes.
In 56 lordship, it was held that
Hmm.
the primary challenge to the impugned judgment is that the consignment was booked from Chirai to Bongaigaon as train load consignment. When the consignment reached Bongaigaon, the claimant was directed to pay different charges as the consignment could not be treated as wagon load but as wagon load. In other words, NF Railway charged freight as per wagon load instead of train load. In this regard, the tribunal has held that the message of the NF Railway is contrary to the resolution of the Railway Board. The above upper tribunal has taken into consideration two judgments of the Guwahati High Court wherein it has been held that the railways cannot charge higher amount by bringing different classification when there is no misrepresentation or suppression by the consigner.
Okay.
Similar.
Very well.
Sorry. These two judgments, Lordship, I would like to raise, sir.
Very well.
And one more thing, Lordship, we have lodged this claim under section 106. There, Lordship, we paid this amount, Lordship, under protest, Lordship. So,
All right.
is there, Lordship?
Okay. Yes, Ms. Fukan, I don't think there is any operation of law. So anything you want to add? Otherwise, I am dismissing this appeal. Sorry, Ms. Sharma, you've done your best, but I do not find. So I'll deal with all I'll give the judgment right away. You want a glass of water? You've argued for a long time. I mean, yes, Matok.
Lordship, the Supreme Court judgment, the para which I would like to rely
Yes, yes.
on is paragraph 16 and 15, Lordship. 15 and 16.
Just 1 second. Decision kita play the time yoga. Baki phone hai.
15, 16,
Hmm?
16, 15.
Ye to phone.
49.
Ms. Sharma, can you find out if you can get hold of this decision? Union of India versus P. Prabhakar.
Yes, Lordship, but right now it is not with me, Lordship.
Can you find out?
Yes, Lordship.
No, you use your mobile phone, or if you have iPad. Union of India versus B. Prabhakar. I may have got the wrong citation, but the party's name appears to be Union of India versus B. Prabhakar, 2006, volume 9 SSC at page 548. Citation may not be correct, but the party name, just find out if you can get hold of that. Lekha. Heard Miss M. Sharma, learned counsel appearing for the appellant. Also heard MS K. Fukan, learned counsel appearing for the
Correct.
respondent. Sorry, learned CGC, learned CGC for the respondent Union of India. The appeal is presented under section 23 of the Railway Claims Tribunal Act 1987 against the judgment and order dated 12/4/2023, passed in original application number so and so of the Railway Claims Tribunal Guwahati Bench, Costa Asylum, whereby the refund claim, whereby the refund claim petition filed by the appellant dash consignee seeking a claim, claim whereby the claim petition filed by the appellant consignee seeking refund of excess compensation, refund of
Freight, lordship, additional freight.
refund of additional freight charges,
Yes, sir.
charges was rejected. The brief facts are that the appellant consignee. Where do I find your claim?
Claim.
Book 21 wagons of iodized salt on and under invoice number to paragraph 2, page 15 at Pamba, under invoice number so and so, dated 39/15, and 21 wagons of iodized salt under invoice number so and so, dated 39/2015, in train load condition. Accordingly, the applicant paid all freight money of rupees 55,08,341 at the time of booking at CHIB by money receipt number so and so, dated 39/2015. Stop. However, it is the specific case of the petitioner, appellant, that on the next day, i.e. on 1/10/2015, the railway at booking point collected additional freight to the tune of rupees 27,54,222 by money receipt number 542025, treating the booking of consignment under wagon load condition, despite the fact that the consignments were booked under train load condition. Accordingly, aggrieved by such additional charges
Yes.
being charged from the appellant, where do I find your claim?
Lordship, claim is in the claim application.
Right, Thomas. I do bite it. Please, take out the claim petition. কি লিখলা? The appellant filed a claim petition before the Railway Claims Tribunal on such and such date. For refund of the excess freight charges levied by the railway authorities. Correct?
Yes, Lordship.
Before the Railway Claims Tribunal, Guwahati bench. For refund of rupees 27 refund of additional question to the tune of rupees 2754,222. The date of filing this is not there, no?
It is there, Lordship. 10th August 2016.
No, filing date to 10/8/2016. The upon receipt of written statement from the NF Railway on 13/4/2021, the following issues were framed. 1, 2, 3, 4 in page 18. Following issues were framed by the Railway Tribunal, Claim Tribunal, which reads as under, quote unquote. Thereafter, upon hearing the parties, the Railway Claims Tribunal by judgment dated 12/4/2023 was pleased to hold the first two issues, i.e. whether statutory legal notice under section, as regards the legality of the statutory legal notice under section 106 of the Railways Act 1989 and the legal title of the appellant in favor of the appellant. However, as regards the issue whether the appellant is entitled for compensation as claimed in the claim petition, the Claims Tribunal held the same against the appellant by holding that there is no merit as regards the contention of the appellant in seeking refund on the freight, and the respondent authorities cannot be faulted with in their action for levying additional freight charges. Stop. Accordingly, the claim tribunal held that the appellant is not entitled for any refund stroke compensation as prayed for. Aggrieved by the aforesaid order of the claim tribunal, the present appeal has been filed. MS M. Sharma, learned counsel for the appellant, submits that the tribunal failed to properly appreciate the evidence and erred in rejecting the claim despite proof of the freight being calculated at rupees
55 lakhs.
55,08,341 on 25/8/2015 at the time of booking the subject rakes. She further submits that admittedly the corrigendum, admittedly the circular applicable as on 25/8/2015 is dated Five 6/2015, under which train load charges is leviable for BNS, for BCN wagons. She further submits that the subsequent corrigendum dated
Eighteen 9/2015.
18/9/2015, which came into effect on 28/9/2015,
Was not widely circulated.
15, whereby 2-point rake load is permitted only in BCN HL wagons, and hence instead of train load charges, wagon load charges is leviable in BCN
HL wagon.
HL wagons. She further submits that since the aforesaid corrigendum dated 30 so and so has not been communicated to the railway authorities, nor has been widely circulated, for which the railway authorities on 25/8/2000, she further submits that the railway authorities, having charged the freight, having charged the rate of the goods as per the applicable rates as on 25/8/2015, i.e. the date on which the indent was placed, cannot be faulted with. She further submits that admittedly on 39/2015, though the subsequent corrigendum dated 28/9/2015, dated 18/9/2015 has come into force. On the date on which the consignment was loaded and transported from
From Chirai,
Cherai, CH,
IRAI.
so and so, cannot be made applicable in the instant case, inasmuch as the same was neither communicated nor widely circulated, and in fact, the authorities themselves admits, which is discernible from the records, that due to want of knowledge, the the consignment was charged under train load charges and not wagon load charges. Stop. She further submits that once the consignment is charged, subsequently the railway authorities cannot charge a higher rate. Stop. In support of her submissions, she relies upon the following decisions. Number 1, Union of India versus MS Arihant International Limited, Division Bench, dated 4/12/2012, Guwahati High Court. It was my orange flag at us, page 53. Number 1. Number 2, Union of India versus Manju Devi Jain, page 55, coordinate bench, dated, judgment dated is 24/5/2013. She further submits that since the appellant has paid the charges as calculated initially by the railway authorities on 25/8/2015 by no, the appellant is legitimately doctrine of legitimate expectation. No, sorry, continue. The subsequent additional levy of additional freight is hit by the doctrine of legitimate expectation. In support of her aforesaid submission, she relies upon Navjyoti Coop Group Housing Society versus Union of India, reported in 1992, Volume 4 SSC 477. Per contra, MS so-and-so learned CGC supported the judgment of the tribunal and submitted that the findings are based on proper appreciation of the evidence and no question of law arises for consideration in this appeal. Stop. Heard the learned counsels and peruse the materials available on record. Considered the case law cited at the bar. Before adverting to the merits, it is pertinent to note that the scope of appeal under section 23 of the Railways Claims Tribunal, so and so, is confined to question of law only. The High Court cannot reappreciate evidence or substitute its own finding of facts unless such findings are perverse, based on no evidence, or arrived at by misapplying legal principles. Did you get that decision? Can you, if you don't mind, you will have to, I'll have to borrow your handset. Just open it and give it. No, you don't have the entire one. There's only para 3.
Yeah, it will. What's this one?
Itu Bombay. Huh? I think. Good. This is not the one. It's quite a long judgment.
basically based on beneficial piece of legislation.
Correct, correct. Into the print level. Yes. Keeping the aforesaid principles in mind, keeping the aforesaid limited scope of appeal in mind, let me now look into the facts of the matter. It appears that the appellant in the normal course of its business applied for the registration of a demand for a total of 42 BCN wagons for the transportation of iodized salt on 25/8/2015. Stop. In accordance with the relevant Railway Board circular dated 16/5/2014, as applicable, the appellant paid, don't say as applicable, the appellant paid an amount of 5,200 towards wagon registration charges, which was duly accepted by the railway administration at the Chirai booking station. It appears that the said 42 wagons were registered under the classification of 2-point destination terminals, stroke 2-point rake within bracket covered wagons. In terms of the Railway Board's rake master circular dated 5/6/2015, it appears that the railway authorities at the time of on 25/8/2015 approved the booking under train load charges. It further appears that on 30/9/2015, the appellant accordingly booked the consignment and dispatched the same. Booked the consignment on 30/9/2015 for the destination Hormati and Dekargaon respectively as a 2-point rake within bracket covered wagons. Stop. It further appears that after submission of the forwarding notes, freight was correctly, it further appears that the appellant deposited the freight of rupees, deposited rupees 25, deposited rupees 55,08341 on 30/9/2015 at the time of booking at Chirai on the train load basis within bracket class 100. However, it appeared that on 1/10/2015, no, however, it further appears that the rake there accordingly departed Chirai on 1/10/2015. It further appears that on 1/10/2015, the railway authorities recalculated the freight under wagon load class 150 and levied additional freight charges of rupees 27,54,222 under wagon load class 150. Stop. It further appears that the appellant vide money receipt number 542025 paid the aforesaid additional freight charges on 1/10/2015. Stop. It appears that though under the corrigendum, though under the circular dated which was that date, the initial circular date? That circular date, that train load charges,
Previous circular is 5/6/2015.
5/6.
2015.
Though it appears that though under the circular dated 5/6/2015, the 2-point rake
Is permissible
for BCN wagons under train load class 100. However, in view of subsequent corrigendum dated 18/9/2015, which came into effect on 28/9/2015, train load class rakes has been specified for 2-point rakes. Sorry. It has been however, specified that train load class rakes for 2-point rakes would only apply to BCN HL wagons and not to regular BCN wagons. Hence, for any transportation of BCN wagons post 28/9/2015, the same cannot be charged at train load class rates and the same has to be charged under wagon load class, right? Under wagon load class rates. Stop. Admittedly, the wagons booked by the appellant under the BCN wagons has moved on 30 has moved on 1/10/2015. Hence, the rate applicable is under wagon load class rates and not the train load class rates. Apt to refer to section 73,
78.
78. Of the
The Railways Act 1989.
Railways Act 20%. It's there in your page 21, huh? You have it? Section 78 of the Railways Act 1989, which reads as under quote unquote. Reading of the aforesaid provision of the Railway Act, it is apparent that the railway authorities has the power to recalculate the freight and other charges and also correct any other error or collect any amount that may have been omitted to be charged. I'll have to borrow your book for the day. Stop. It appears that the railway authorities, having realized on 1/10/2015 that the freight has been incorrectly calculated and collected from the appellant on 30/9/2015 as by 30/9/2015 the circular dated 18/9/2015 has already come into force, whereunder instead of train load class rates, the BCN wagons ought to have been charged under the wagon load. Stop. I do not find any full stop. Now turning to the relevant paragraphs of the judgment and the appeal, which reads as under quote unquote করে দিবা, huh? 10, 11, 12, 13, 14, 15, 16, 17, 18. Reading of the aforesaid findings of the tribunal, I do not find any error or irregularity committed by the tribunal. Accordingly, the appeal fails. Dismissed. Sorry, but I must appreciate your hard work. And the note that you have prepared has also assisted the court to immediately pronounce the judgment in court. This is the kind of assistance that the bench looks forward from the bar. Deeply appreciated.
Timing item number 1.
Yes,
Yeah, please, your lordship. This is a transfer proceeding, my lordship. My lordship, this is a transfer proceeding of a suit filed under section 1A of the Fatal Accident Act, my lordship.
yes.
My lordship, I am praying for transfer of the proceedings from the Honorable Court of Civil Judge Senior Division Tinsukia to the Honorable Court of Civil Judge Senior Division Lakhimpur, my lordship. Lordship, my grounds, before proceeding to the grounds, I'd like to state a factual position. My lordship, the son of the petitioners before your lordship are parents of the deceased who are ages 66 and 63 years old.
60 parents of the deceased.
Deceased, my lordship.
66 and?
And 63 years old. Father is 66, mother is 63.
Yes.
My lordship might have gone through a news article with regard to paragliding in Tinsukia in Skylight Resort when one youth expired, my lordship, deceased. My lord, what happened was that they have introduced one paragliding event in which they were asked to participate with a fixed rupees of 700 or something. On 26th of January, the victim, the deceased, he along with his 2 friends went for paragliding. In that, in front of they were stated that there is an expert team, and it was advertised all
There was an
expert team for paragliding, and it was advertised all along in Assam also. So he went from Lakhimpur to Tinsukia for that in Skylight Resort paragliding. He was, while doing the incident, some accident occurred. But the irony of the part was that when he got down, he was alive. The manager and the waiter of the resort, they escaped from the place with their vehicle. Had they taken him at that point of time to hospital, he might have been alive because the 2 friends brought a vehicle, and at that time he was alive, but he's coming to his injuries. My lordship, in between the FIR was lost at Tinsukia proceedings with regard to the criminal proceedings are there at Tinsukia. My
So
lordship,
this is transfer of what proceeding?
the petitioners herein as plaintiff have filed a petition under Fatal Accident Act claiming compensation.
Compensation. And this is the family of the deceased.
Family of the deceased.
You are for?
I am for the father and the mother.
Of the deceased.
Deceased. We as plaintiff, as because of jurisdiction has filed the suit there, my lordship.
At where?
Tinsukia.
Tinsukia, because this happened there.
It happened there.
In
my lordship.
Tinsukia, but
As
you are a resident of Lakhimpur.
Lakhimpur.
Yes.
My lordship, then in between there were respondents. Altogether there were 7 respondents, out of which 1 respondent did not appear and proceeded ex parte, in which the 6 respondents appeared who are also party to these proceedings.
This is a civil proceeding.
My lordship.
But you don't have to go.
My lordship, here the.
You have to engage a lawyer.
Yes, my
You are
lordship.
66.
Yes, my lordship, I have stated.
66
that-
and 63 is not old.
No, my lordship, it
In,
is not.
I
it
don't
is
think
not,
so, Miss Counsel.
Yes, no, my lordship, I have
The-
stated clearly, it is, my lordship, I have stated clearly in this petition. I'm aware that my lordship, since it's a civil suit, it can be engaged. But the fact is that all the witnesses are from Lakhimpur.
No, but
with
the
regard to
incident happened at
Tinsukia.
Tinsukia.
Yes.
How can all the witnesses be from
My lord,
Lakhimpur?
my lord, the conservator, my lord, here, with regard to.
But you see, maybe his friends who were with him
Yes.
are from Lakhimpur.
My lordship.
But what
here-
about the other witnesses?
My lordship, this
What
is
about
under.
the prosecution witnesses?
My lordship, this is.
Where are they from?
My lordship, it is civil proceedings, so prosecution witnesses will not come in. By the way,
Okay, but
by the here,
defense
defendants-
witnesses, sorry, I stand corrected. Defense witnesses would be there.
defendants are, my lordship, they are, my lord, they out of the six.
And
defend-
counsel, you have to give your evidence in affidavit
Yes.
only for
My
cross-examination,
lordship,
only for cross-examination.
yes, my lordship.
And nowadays, is there any facility for video, online? That is
In
there.
fact, my lord, the
My-
similar issue,
uh,
Supreme, if I may submit.
one
Just
submission.
one second.
The Supreme Court has even directed, there's a judgment which I have brought on, my lord, even I've relied it, it's there. Where the Supreme Court has said that if the.
I'll
overage-
take it later.
Yes.
Let me complete
that
this, but
emotion-
yeah,
yes,
just cut
the
it
video
short.
conferencing can be allowed.
That is a
Yeah,
permission.
yes,
All
that
right.
is permissible.
Yes.
My lordship, out of the respondents herein, my lordship, the respondents, out of the respondents out here, only respondent number 6, my lordship, is from Tinsukia. He is 26 years old. He is the main proprietor as per our claim petition. He is 26 years old. Out of the other respondents, my lordship, respondent number 5 is from Dhemaji, my lordship. And the other respondents are also, my lordship, they are the DC, Superintendent of Police, Tinsukia. And the main respondent, that is respondent number 5, he's from Dhemaji, my lordship. So, my lordship, out of the respondents,
So you are saying that it would be convenient to all.
on more or less, my lordship. If
Is that what you're trying to say?
Yes, my lordship, because there's 6 defendants, my lordship may.
You
what-
have that list somewhere here.
Yes, yes, yes.
Where?
They are also the parties.
Where?
My-
Which page?
My cost title, page number 2.
No, but that ground you must have taken.
Yes, my lordship, I have stated.
No, you understand what I am saying?
Yes, my lordship.
You must have drawn a chart or something to show where these defendants and the petitioners are and the witnesses of the plaintiffs are from.
My lordship,
Because what I'm trying to
understand.
uh, I may be wrong in understanding, but correct me if I'm wrongly if I've understood you, that not only the plaintiff witnesses, but almost all of the witnesses except one, I think, of the defendant are also from outside from Tinsukia and would be comfortable for them also to attend the court at Lakhimpur. Is that what you are trying to project before this court?
The respondents, my lordship. My
Few of
lordship,
them.
My lordship, kindly be pleased to peruse page number 2 of my cost title.
Yes.
The respondents herein are
DC.
defendants, my lordship. The Deputy Commissioner Tinsukia, my lordship. Number 2 is the Principal Chief Conservator of Forest, is Panjabari, my lordship. 3 is the SP Tinsukia. 4 is DFO Tinsukia, which falls under, my lordship, the relevant 5, that is the DFO Division Dhemaji, my lordship.
DFO Tinsukia falls under DFO Dhemaji.
Dhemaji, my lordship. It falls under that
My lord, the
Yes.
forest department would be in a. better
Dhemaji,
situation.
my lordship.
But they don't
they-
have to all go for giving witnesses.
My lordship, here in this case, that is a.
See, you understand
Yeah,
what I am
my
saying.
lordship, while
You
drafting
see,
this petition also, I understood, my lordship.
yes,
Well-
because otherwise, in every cases,
No,
they will proceed because the whole concept of jurisdiction under
Yes, ma'am.
section 19, 19 and 20 of CPC.
24.
huh?
It's under stands for section 24.
No,
No,
but
no,
CPC
jurisdiction is 1920.
is 19.
Not is correct.
19.
Then that will have to be as per convenience. And it cannot be casually transferred also.
My lordship,
A
here, I-
case has to be made out
Yes.
where for the interest of justice, convenience of parties, yes.
yes.
If a case is made out, the court can exercise
My-
powers under
Here's my
section
grounds.
23, 24.
24. My lordship, here my grounds are, my lordship.
Yes,
In my petition, while drafting this petition, I was aware with regard to that point.
the
my lordship.
limitation.
Yes, my lordship. So while drafting the petition, I have stated in my para number 6 and 7, the main grounds of mine here is that, my lordship, with regard to jurisdiction, Tinsukia Court is the jurisdiction where the cause of action arose. And my lordship, it is also an admitted position that for all the cases that have been filed, my lordship, are filed within jurisdiction only. But still section 24 role plays in many of the cases, my lordship. Here the peculiar case with regard to me is that, my lordship, I be pleased to peruse that I have stated clearly that there is complete mental agony, depression, anxiety with regard to the petitioners, my lordship.
Page,
My lordship, I have stated page 10, my lordship will be pleased to peruse. Last 5th line, I have stated from last 5th line, para number, page 10, para 6.
Yes.
I read only the relevant, my lordship. In along with it, the petitioners are suffering from extreme mental agony, depression, anxiety, and have experienced sleepless nights and also the trauma and death of the beloved son who has shortened the life of the petitioners, my lordship. Moreover, that bus journey, it takes around 8 hours, my lordship. 8 hours, my lordship. And moreover, with regard to the respondents, my lordship, respondents are
Senior
not-
citizens,
My lordship,
66
my
and
lord,
63.
My lord, in all circumstances, senior citizens' role will not, my lordship, here, the
They're not
son
senior
expired
citizens.
66 and 63. My lordship, the son expired, their condition of their mental health along with this, my lordship. 26 years old son expired, my
Then
lordship.
that
Yes, my
court
lordship.
fully empathizes
Yes,
with
my
their sentiments.
And with regard to the
But you
defendants
see,
also, my lordship,
that
if-
cannot be the sole criteria
Yes, my
for
lordship.
transferring, no ma'am.
Yes.
This court has to also take the all the consider factors, because I think Mr.
And my-
May I
Yes,
submit, ma'am?
Hmm?
my lord-
I'm appearing for the private respondent here, but my lord may I submit two things. if
So,
allowed?
but you are objecting, isn't it?
Yes, I'm objecting on this, my lord, because first.
All right, I'll hear you.
Yes.
Let we will continue after post lunch. It's already 1. So I'll hear you patiently, not to worry. But I'm just indicating my
Yes. Because my lordship, here in this.
the
case-
anxiety, because
Yes, I
you
am
see,
aware. I
it's
am
a
aware.
transit. So are you carrying any authorities?
No, my lordship, I haven't, because my lordship, today morning, one of my junior has mentioned, that my lordship, actually, I've informed my brother also, actually, I started because of some emergency, I have referred to Dr. Lilim Deka. He has given me continuous 10-day physiotherapy session. So today morning, as
You
item
have
number
some
1, yes, that is why I
problem.
have mentioned before your lordship.
All right, you
that
wanted another date?
Any other day, I've.
Yes, when do you want it? When it would be convenient for you to come to court?
More সুবিধা আছে
Only none of that.
এইটো সপ্তাহ লৈ ল'ম নেকি 17th পৰা 24th very first 28th
28.
It will give as pray
November.
for
November.
Namdeepa.
so
All right, you
You
just
know,
indicate the date, he will
Yes,
give it, huh?
My,
Okay,
6th of November.
that was, I have mentioned as.
all
item.
right, no problem.
Standing item number 7.
Yes.
Is on legs. She will be here in the meantime. May the other side start.
It's your petition, you are the petitioner.
Uh,
What will the other side start? Unless you plead,
Lordship,
They are
she will be here by in the meantime.
then you start, because he'll only responds to the arguments.
Then Lordship may
The,
take
the,
a-
the respondent, you want the respondent to start, you want the respondent to make arguments for your case. Huh, Mr. Counsel?
In the
You-
first half, your lordship had,
Huh?
in the first half, your lordship had instructed to go through the.
Yes. You start and your senior colleague will join you. Why don't you start? Why are you wanting them to start? Yes, what's your name?
M. Ahmed.
Huh?
M. Ahmed.
Ahmed. Yes, Mr. Ahmed, what is this civil revision petition about? What order is under challenge? Where is that order? Which page? Yes, please tell me the page. Mr. Ahmed, this court clearly indicated you at about 10:40, I think, at around that time this matter was initially called.
Lordship, actually, I am not fully acquainted with the facts and progress of the.
You see, Mr. Counsel, you need not be fully acquainted and conversant. You are appearing before this court right now. This court asks you to go through the brief. I think that much you can do. You could have find out what is this petition. What do you do to find out what a petition is? First of all, this petition is filed under what provision of law? It's a revision petition?
Yes, Lordship.
Under what provision of law? By now, you should have found out that
Yes, Lordship.
115 or 227
115, Lordship.
of CPC.
CPC.
And it is challenging what? Some judgment?
Judgment.
Which judgment?
Judgment and decree passed on 14/12/2000.
Now find out in which page that judgment is. What is there to be acquainted about it? Mr. Counsel, you see, when the court asks you to give the assistance and give you some time,
Lordship.
minimum that much you can do. These are the opportunities. Yes, Mr. Counsel, I'm talking to you.
Yes, Lordship. Lordship may see refer page number 72, Lordship.
Yes. So now you please look, Mr. Counsel, can you look this side?
Yes, sir.
You see, I'm not trying to, you see, I'm only trying to help you.
Yes, sir.
These are the opportunities. Very few gets them. When this court is giving you an opportunity, you must grab it. You need not be fully acquainted on everything. You could have just read the basic things of the brief and could have pointed out. This court is aware. This court is not going to pass any orders that will be prejudicial to your interest without hearing your senior colleague. But these are opportunities for you to grow.
Yes, Lordship.
And don't take the constitutional court so casually. You are again looking down. When the court is talking to you, please show that respect, Mr. Counsel. Any difficulty?
No.
Page? Yes, page
72, Lordship.
72. You are who? You are the petitioner or the respondent in the original suit? Mr. Counsel, you are?
We are opposite party, Lordship.
Here the petition.
You are the petitioner in the original suit. And it was allowed.
Allowed.
Your allegation was that the
Grabbed.
respondent had grabbed your land. Which part, where is the operating part of the judgment? Which page?
Case is, point was decided, my lord.
Page?
Page number 79.
Page number 79.
79.
That is point, cause of action.
Yes, ma'am.
That is all. Now,
81 is the relevant issue.
81. Mr. Ahmed, read para 8.1.
In this regard, apart from adducing evidence by the PWs 1 and 2 supporting the ownership over the suit land, the petitioner side has exhibited the sale deed number 1088 dated 15/3/2014, by which the petitioner Tajuddin Lashkar purchased the suit land from Hilaluddin Lashkar. In the recital of the said documents, Exhibit 1, it is clearly stated that the vendor had been in possession of the suit land which he had purchased on 16/11/2007 by registered sale deed number 3501 of date year, and thereafter on the date of executing the sale deed, Exhibit 1, he has delivered and handed over the possession of the said plot of land to the present petitioner. Said fact is vividly deposed by PWs 1 and 2 in this evidence, and their evidence would not be rebutted by the opposite party, except putting a suggestion. And a suggestion without admissible evidence cannot wash away the case of a party which is supported by admissible evidence. It is the settled principle of law that documentary evidence prevails over oral evidence. Thus, in the absence of anything contrary, it is clear that it is the PW2 Hilaluddin Lashkar who is in physical possession of the suit land till he sold out the same to the petitioner Tajuddin Lashkar, and on and from 15/3/2014, it is the present petitioner who has been in possession of the suit land.
Mr. Counsel, please refrain from using your mobile phone when you're addressing the court. What kind of a behavior is this, Mr. Counsel?
No, Lordship, I've asked my senior to.
Mr. Counsel, before any other court. Yes, next. Mr. Please advise the young gentleman here the manners of the court. Yes, next matter, please.
This case, my lord, the error, my lord, has been noticed, my lord. That is, appeal has been filed, interest appeal has been filed under section 299 is mentioned. Only twice, my lord, the cost stated here, my lord. It should have been 384 of the Indian Succession Act.
There has been a inadvertent mistake.
Inadvertent mistake, my lord. Probably IA will have to be filed, probably. Yes.
This is under what provision you have
It
filed?
should be under, actually, a succession case was filed under section, application was filed under section 322. And appeal against any order either refusing or allowing, my lord, it should be under section 384 of the Indian Succession Act. And inadvertently, my lord, 299 generally, in will and probate case, we file appeal, my lord. And it somehow it passed the registry also, we remain unnoticed, my lord. Only the cost title and in the.
You do whatever is required.
Yes.
Heard Mr. M. Patgiri.
No, my lord, A. Chaudhary.
Age?
A. Chaudhary.
Chaudhary, learned counsel appearing for the appellant. No one appears for the respondents. None appears for the respondents on call. Mr. Chaudhary submits that due to an inadvertent mistake, an error has crept into the
Yes, the cost title.
cost
and the
title
synopsis.
and the synopsis of the
This memo fake.
memorandum of appeal. He accordingly submits that he accordingly seeks accommodation to do the needful in this regard. Prayer is allowed to relist after 2 weeks, 3 weeks or 2 weeks
After 2 weeks.
on a date to be fixed by the registry.
All right.
My lord, earlier matter may pay for a date, my lord, because it is a hearing matter, otherwise it will not be listed.
Relist Korea that on when do you want it?
Remember. Obliged.
Item number 12.
May please. May the appeal lordship, I have come against the matlab the.
What about the respondents?
Matlab the name has been shown in the cause list, I have seen matlab. But
MS Eldas. Yes. What to do? You are the?
I am the matlab the petitioner there in the matlab court below, my lord. And here I am the appellant, my lord.
No, you are the wife or the husband?
I am for the husband.
You're the husband. And the divorce was granted,
Divorce was not granted,
not granted.
not granted.
Against that you have come.
Against it.
And the wife has contested.
Wife had contested.
On what ground?
My lord, in fact, my lord,
No, on what ground divorce was sought?
Divorce was on the ground that she is not allowing me to, on cruelty ground, my lord. She is not allowing me to enter the house, my lord.
Enter
Since,
whose house? Your house?
My house, my lord. I am serving, now I am retired, my lord. At that time, my lord, I was serving in, my lord, India Air Force, my lord. And whenever I used to come home, my lord, on leave, my lord, she did not even allow me to enter the house.
Evidence
Since,
is there.
Since 2021, my lord.
Evidence is there.
Evidence, my lord, is evidence is there, my lord. That is, my lord. And my lord, because of that, my lord, I was staying since then, my lord, since 2021, my lord, I am staying separately, my lord. Even in the cross examination of the, my lord, my wife, my lord, she has stated that I am staying separately for last 5 years.
Who has said?
That is been
The wife.
wife by also, my lord, in her.
So no purpose would be served to carry on with the marriage.
No, no, my lord, I am also staying, my lord, not with her, my lord. I am staying separately in my
Since
brother's house.
last, when have you been staying separately?
My lord, since 2001, my lord. In
Well,
fact, my lord-
I'll put this matter on Tuesday. If on that date also nobody appears, we'll proceed ex parte.
Lords,
Heard Mr. UJ Saikya,
lords.
learned counsel appearing for the appellant. None appears for the respondent wife, despite name of MS Eldas being reflected in the cause list. This is item number 12. Oh, sorry. Mr. Raju Deori. I thought this was item 11. So and so. Huh? And this is listed today for hearing, isn't it?
Here it is.
Ki likhila? Despite the matter being posted, being listed today under the hearing column, reflecting the name of the learned counsels, including the name of the learned counsel appearing for the respondent wife, i.e. Shri Raju Deori. Since the case records has already been are available on record, and the learned counsel appearing for the appellant insist an early hearing, the matter is redirected to be posted on such and such date, on which date, if there is no representation on behalf of the respondent wife, the matter shall proceed in accordance with law. Where's the petitioner?
14 and 15. 14, 15 weeks. I'm not. Sorry.
14. None appears for the petitioner on call. It appears that the instant, Mr. Your name? The Rathi present for respondent. It appears that the instant appeal is pending since the year 2013 and was last posted before this court on 28/9/2021. However, since after lapse of several years, the matter has been listed today, relist on such and such date with intimation to the learned counsel appearing for the appellant by the registry.
13. Much obliged. 15 and 16.
15 and 16 are connected matters, my lord. My colleague, my lord, Koustav Gogoi is appearing in 15, my lord. He's on legs, my lord. in another court, and my lord, my item is 16, my lord, and my lord, I have actually even missed the item actually. Can it be taken up tomorrow, my lord? If my lord, you're not in for opinion.
Tuesday?
My lord, my lord.
Tuesday আৰু কিবা দিছিলো নেকি এইটোৰ বাহিৰে এতিয়াহে দিয়াটো sprayed for relist on Tuesday, such a list.
Deeply opposed.
Item number 17.
Given 17 is K Gogoi, it must be probably cost of Gogoi only then. So see item 17,
Similar issue is there, ma'am.
similar issue,
Similar issue.
the same Gogoi then.
Yes.
Sprayed for relist on after 2 weeks on a later.
My lord, there is a stay, interim stay operating in this matter. There is a urgency.
So when do you want it?
My lord, if this item number 15, 16 and 17 can be taken up, my lord, on Monday or Tuesday,
Okay, Tuesday, correct.
much pleasure.